Thank you. Since I'm the last to speak, I'll try to be very brief. The appellate board, as you know, is a collegiate body that reviews extrajudicial disputes with regards to registration and post-registration of industrial objects. And according to the respective law, when the members of the appellate board make decisions, they are independent, and the patent office ensures the organizational and administrative functioning of the board. Today I will speak only about the trademark cases. Though we review appellate cases also on designs and patents and additional protection certificates, I will focus just on inter partes disputes with regards to trademarks. There are also cases on designs, but during the last few years we haven't had any cases on designs. So, on absolute grounds, to refuse trademark registration, we'll have one appellate case, the latest, that made us ask separate complex questions that we needed to answer in this case. First, about absolute grounds for refusal. Whether the trademark contradicts the public order and morals, whether the trademarks has high symbolic value, and there were also some procedural aspects that we faced during the case. Then there were also relative grounds, for example, comparison of two cases, and also possibility to mix up these trademarks, and also proof of evidence, and also proof of use. And also what Zane Peterson already touched upon with regards to the application of these legal norms, namely when the five-year period starts, during which we need to start using the trademark. And this has become topical since last year, when we were also tasked with revocation cases. Appeal case for trademarks, joint case, and we see that there are various elements, words, graphical elements, and so on. There were various options what concerns the graphical element. There were several arguments pointed in the refusal of the patent office. Basically, it's a man in a long coat with a key in his hands. I would not see just a cross there. To me, it looks more like a wind pointer. And this mark includes words in 4 languages, in Latvian, Russian, German, and English. And the trademark was requested for printed materials, for organization of various exhibitions, religious education, and various cultural events, and also for organization of religious meetings. When we look at this combination, there is a physical person and also the name of one of the most important Latvian churches. So when we look at this combination, then we have to ask whether an individual may claim such unique right to use just this name. And by referring to the honorable judge, I would like to say that the intuition and conscience says that this probably would not be the right decision, that someone individually would get this right. The patent office refused this registration by relying on the public order argument, because this sign would include something that has a high symbolic value for the Latvian public. So we assessed when the norm on the public order and morals can be applied and to whom these norms can be applied. We also assessed whether this specific designation has high symbolic value. And also separately, we looked at some sentences in the case file that made us think what are the borders, what are the lines, the red lines of the case. And also, we were asked to invite a third party into this case. So first about the public order and morals norms, namely that the trademarks cannot violate these norms. Initially, maybe the wording of the refusal was different, but the final version, during the final stage, when we had to hear the case on its merits, this argument was formulated as follows, that the trademarks are not immoral or against the public order, but registration of such trademark for an individual would not be in line with the public morals. The appeals board replied that this norm that stipulates that trademarks that violate public order and morals are not registered, namely this norm in no way include any aspects that would relate to the fact that when someone submits such a request is actually violating public norms. So basically, we should not assess the conduct of the person by submitting a request, but we have to review the actual trademark, requested trademark. And when we looked at the trademark itself, we did not see anything that would be against the foundations of the public or national existence. It's not rude. It's not religious. It is not offensive what concerns religious beliefs. There is nothing immoral there. So this norm cannot be applied to this case. High symbolic value. Does this trademark contain something So basically, trademarks are not registered if they have high symbolic value, including religious symbols, if they are relevant or important for the Latvian public. High symbolic value. Of course, we cannot attribute that to the graphical element, at least in our opinion, because though the cross is there as a cross, we cannot really perceive it as a religious cross. It's more as a support for this wind direction part. So the appellate board supported the patent office and agreed that the image of Peter's church and link with this trademark, it has high symbolic value. Having read the case, we established that this church is considered a national monument. It's a part of cultural heritage. And in this case, the name of the church was used. Of course, if it was just a touristic site, then it wouldn't have this symbolic value. But considering this totality of circumstances, and also with regards to this church, we have a special law, and we, of course, also know the circumstances surrounding this law. But in any case, there is a separate law, and I think there's also a special law on Aglona Basilica. So if there is a law, it has to be very important for the Latvian public. And the last conclusion was that the registration of such trademark for an individual would mislead the public on potential link between the owner and the respective physical building that has this high symbolic value. Thus, this ground for refusal was found valid, and also the appellate board agreed that the trademark cannot be registered. During this case, we also started thinking about the limits of the dispute. According to the law, we can rely only on the arguments that are indicated in the disputed claim. Having read the final version of the case file before we started hearing it, we saw that a sentence has appeared that maybe the applicant had acted in bad faith, and this was not included in the initial version. So we had two options: either stick to what is in the case only and only in the case, or maybe we can also rely on the law and return the case for re-examination. And we thought that if we can find the trademark not registrable on one ground, then we should not return for re-examination just to save the time. And third thing, we were asked to invite a third party, a foundation of the St. Peter's Church. We checked the register of enterprises, and we saw that the claimant and one of the officials of this foundation shared the same surname, so probably they were relatives. And according to the law, a third party can be invited only if the decision in the case would affect his or her or its legitimate interests. It was established that such interests could be affected and that the opinion of the foundation could be relevant for making the decision. So the appellate board, this was claimed by the claimant. But as an appellate board, we thought that the relevance was not high enough, and also the legitimate interest was in no way substantiated, except for the fact that according to the St. Peter's Church law, this foundation was granted the building and the land on which this building is located, but with a condition that if the foundation does not meet the legislative requirements, this property can be disposed of for the benefit of the state. But in no other cases it could be done. So if we thought that the opinion of the foundation could be relevant, let's say if this foundation could have a right to this specific trademark, and if they fail to meet these requirements, then the land and the church would be returned to the state. But what would happen with the trademark, as this exclusive right to this trademark? So we rejected this request to invite a third party, and this decision has become final. And now about relative grounds for refusal. The previous sign is on the right side and the challenge trademark on the left side. So Brilla and Brilliant concerns various alcoholic drinks, spirits. There is visual and phonetic similarity because the first 5 letters are the same, but semantically these signs are different. So they are semantically different, and the semantic difference can neutralize the visual and phonetic similarity. On the left, we see brilliant. In Latvian, it is spelled very similarly, and when the consumer sees this, he or she would think about brilliant like a gem, instead of Brilla that he or she might have seen some time ago. So this objection was rejected because there is no possibility of confusing these signs, because these signs are semantically different, because we already know about the ECJ judgments, for example, Picasso case, Picaro case, and so on. So due to the semantic difference, these signs cannot be confused, and the decision has become a final. So now about the possibility to confuse two signs and damage to the owner of a reputed trademark. So two signs with the same word, Wenden. In one is simple V, regular V, and the other double V. One is used for various non-alcoholic drinks, and the challenge sign used in on beer and spirits except beer. And the objection relies on two norms, namely whether it is possible to confuse these signs, and also the owner of previous sign. The graphical sign was registered, but the word sign was not registered, but it was claimed that this is a well-known sign. So the claimant claimed that a well-known trademark is used on goods that are not similar. And basically, it was claimed that non-alcoholic and alcoholic drinks are dissimilar, and the word sign was still used on these two different types of goods. So what concerns similarity? Of course, the words in signs usually have greater distinctive characters and graphical elements. We know the Dace's castle. There's also even Dace's written there. Brewery is clear. So basically, it's a place where beer is brewed. And then we can ask whether the word Venden, and this is the old name of the town called Daces. Several centuries ago, this town was called Venden. And we had to ask ourselves whether the consumers would perceive it as a geographical name, place of origin, or this word can be used as a trademark because it wouldn't have this this meaning of origin. It was considered that this name can be used as a trademark because no city, no town with this name exists at the moment. Thus, it has more sentimental meaning. Yes, this word could be appealing to the commercial operators operating in this region, but anyway, this word could still be used as a trademark. And we found these trademarks similar. And now about the similarity between goods. In one case, there was beer and other spirits versus non-alcoholic drinks, soft drinks. On the one hand, there is these goods are not so similar because they are spirits and they are soft drinks. We drink soft drinks to quench our thirst, and spirits we drink to intoxicate ourselves. So this purpose differs. The purpose of these goods differ. At the same time, considering the fact that everyone wants to drink beer and wine and still drive afterwards, the manufacturers adjust to the demand and they start producing non-alcoholic beer and non-alcoholic wine. And when we order beer, we can be asked whether we want alcoholic or non-alcoholic beer. And we know that there are producers who produce both types of beer or both types of wine. And there are also producers who produce soft drinks, beer, and spirits. So in this regard, there's a similarity. But as beer is the most similar to the soft drinks, we thought that there's a possibility to confuse these signs only with regards to beer. But then there was also a second claim, namely that the trademark is widely known. We, as persons who have to settle a dispute, and if one party claims that the trademark is known, well known, for us it's very difficult to forget that we are also regular consumers. We consume this water. This company delivers drinking water to us, and every time we drink the water of this company. And when we have to decide on this dispute, we have to forget that we see this water every day. And the materials submitted by the claimant were quite conclusive, quite persuading. And there were time periods, there was a survey even, and there were other materials. So there was no doubt that this is a trademark well known in the public. So on the grounds that this is a well-known sign, it was possible to apply the norm that the owner of a well-known trademark can ask to find invalid a similar sign that applies to dissimilar services and goods. So the other sign was found invalid what concerns soft drinks. So it was voided altogether. And now the next example that will pertain not to the entire case, but just one aspect of a case with unreputed signs. So, looking at the sign on the left side, we know who submitted the claim. And Tommy, Tommy Jeans, and Tommy Girl are registered trademarks. Tommy Jeans registered in Latvia, Tommy and Tommy Girl in the EU. The claim is based on two norms, whether it's possible to confuse these signs or not, and whether the earlier sign is a reputed sign. We satisfy this claim, but only to the extent, or only on one grounds, that it is possible to confuse these signs because they are similar, because they have a similar principle behind them. Of course, there is this graphical element, but basically it's Tommy plus something, life, jeans, girl, or whatever. But we did not agree with the claim or with the objection that the trademark can be voided if it's similar to a registered trademark that has good reputation, good standing in the respective territory, because the only evidence about the good standing of the trademark included also Hilfiger. And there was no information in particular to these signs, but there was evidence on the good standing of Tommy Hilfiger sign. And the only evidence was just a T-shirt with Tommy on it. And we could even argue whether this is use for the meaning, for the meaning or in the meaning of the use of the trademark. Because by wearing a T-shirt like this, I can also tell the public that I like Tommy Hilfiger. The claim was satisfied, but not on both grounds. Because the word Hilfiger actually affects the distinctive character of the trademark, because Tommy is a person's name, but Hilfiger is also his surname. A use of an earlier sign. A claim that relied on an earlier trademark of the claimant, and the owner of a later trademark can prove the actual use of an earlier trademark. In this particular case, the earlier sign was registered for spirits and registered a long time ago, and the owner of the later sign asked to submit as the proof of use of the earlier sign, and the owner of the earlier sign could prove that this sign was used for services, retail services, because it's a shop. But in the list of goods, there were no retail services for the sale of spirits. And there was no proof that this sign was used on goods. Thus, the use of the earlier sign was not established. And there were also other aspects that were not satisfied, but one of the aspects was that it was not possible to prove the use of the earlier sign on goods for which it was registered. And the last thing I would like to speak about goes hand in hand with what Zane Peterson told yesterday, namely about the application of the trademark law in time. Which law should be applied at which time or with regards to which period of time. So trademarks can be voided on various grounds, including if the trademark has not been used during 5 years. The problem is when we have to start counting these 5 years. So we have 3 laws, as Anna said. We have the current law that stipulates that from the day when the registration procedure is completed, because there is also an objection procedure. There was a previous law that was in force from 1999 to 2020. The 5-year period had to be counted from the registration day when the trademark was registered, and the previous version said 5 years during which the trademark was not used. We have reviewed these revocation or voiding requests. We have concluded that though we are not really clear when we have to start counting this period, it still hasn't resulted in any wrong decisions. The problem is that none of these laws contain transition provisions. Because usually when we prepare laws, we indicate when is the effective date. And when the patent office works with signs that are registered according to the current law, this date is indicated in the respective documentation. But those that were registered according to the previous laws, they don't have this date in the documents. So we cannot really establish when this date was. Of course, we can add a 3 months objection period with regards to signs that had a decision made on granting the trademark. But if an objection was submitted and a decision was made on merits, then basically someone from outside the system cannot really establish this date by entering the IS system of the patent office. Maybe patent office can do it itself, but the court, I don't think, can do it. Maybe it's not a decisive thing, but I know that in one case has been stayed in court because this matter became relevant. Because we also had a case that has been suspended at the moment, as the respective trademark was registered in 2014, and there is a claim asking to revoke the sign due to the lack of use. And now we have to decide which law will be applied by the court. Whether the proof of use has to be submitted according to the old law, there is one requirement, and according to the new law, there is a different requirement. And the court will have to decide. Yesterday, we spoke about the transition provisions. And I don't know whether at the moment when the law has been in force for 4 years, can we really amend the transition provisions at this point in time? Most probably not. So this will be in the hands of the court. That will be used as a case law for the following decisions, and also for that will serve as a guidance for the appellate board. The new norms are quite beneficial for the trademark owners because according to the new norms, until the administrative proceedings are ongoing, the use should not be started, which actually extends this 5-year period. But at the same time, I'm not an administrative and criminal law expert, but I think this norm is mostly used in administrative and criminal law. Basically, there is this principle that if there is a beneficial norm, then the more beneficial norm should be applied. But I'm not sure if this is valid for civil law cases. But if the trademark was registered according to the 1999 law, they knew that the use had to be started 5 years after the registration date and not after the completion of the registration procedure date. And the parties so far haven't had a dispute on this aspect, and probably this aspect was not decisive in the cases that have been settled in court. And the last thing what concerns these revocation cases, who can submit a request to the appellate board on the revocation of a trademark due to the lack of use. According to the law, it can be done by any stakeholder. Having read the case law of the ECJ, and also considering the opinion of the EU IPO with regards to these words, any stakeholder. Basically, from this we can conclude that it can be any market operator, any market participant, even without any legitimate interest in this. And we can read that in the summary of the Supreme Court on the cases related to various IP rights. So basically, any interested stakeholder can raise such a claim. Basically, we don't ask this person or this company to prove anything. If I am a commercial operator, probably I wouldn't start using a trademark until I make sure that a competing sign that is not used is not revoked. If I start using and then ask for revocations, that I'm basically I have committed a potential breach. So this would make any commercial operator a stakeholder, just because this company could become a competitor of the owner of the trademark. So far, we have concluded in 5 decisions. We have had 5 decisions during the last year. No one has appealed this decision in a court, so we don't know what the court would decide. But maybe the court could have a slightly different opinion. But let's see.